Good afternoon, everyone. My name's Ian MacArthur and I'm head of the Good Employment Charter Unit. And welcome to this, our latest Supporters Network webinar for the month of March 2001. I make that emphasis because this time last year, in fact, it was the 11th of March 2020, we had another employment law session with actually Karen was there as well from Acas, who's joined us today. And that was our last physical event. For those of you who may have attended that day, we met in the, just to remind you, in lovely new meeting space just on Ancoats. And what a year we've had since. And lots of things have changed for all of us, and particularly in terms of some of the challenges around employment law. So I'm really looking forward to the session today with Karen and Lee Jefcott, who's a partner and employment lawyer at Brabners. Before I ask Karen to speak, and for those of you who have not been on these calls before, these webinars before, we do use the platform Livestorm. It works best on Chrome. So if you're trying to look at this on another browser and you're struggling, maybe just come out, download Chrome, open up Chrome, and use the link to come back on and join us. If you've got any problems throughout it, just hit refresh and hopefully things will sort for you. On the right hand side, you will see chat and questions tabs. It'd be great to get some questions for Karen and Lee as they go through the presentations today. But also please use the chat function. The chat function is there so that we can still network, even though that we're socially apart. We can still talk to each and work with each other through these webinars. And finally, just to say that we do record all of our webinars and they will be available after the event, both on our YouTube channel and on our website. So without much further ado, I'm going to ask Karen to come in and start the employment law update. As I said, lots of things have changed in the last year, and some of the things that Karen and Lee will talk about, we wouldn't even have dreamt about this time last year. So I'm sure it'll be a really interesting and informative session. Karen, over to you.
Thank you very much, Ian. And yes, I can't quite believe where the past 12 months have been and the journey that it's taken us on. I remember the last session fondly from last year. And I thought it was my last face-to-face session, but it turned out it was my penultimate one. I started a training session on St. Patrick's Day that lasted about 10 minutes, which was just after being told that we were having to stop all face-to-face training. So it's still lovely to be able to deliver, although slightly differently. And thank you all for joining us today. It's always lovely to come to these sessions. So it has been a busy 12 months in employment law. I'm not going to try to squeeze it all into the next kind of 20-25 minutes. So I've picked out some key talking points in employment law currently. We're going to address the debate about no jab, no job, which you may have read some things in the press recently on. Alongside that, we'll discuss workplace testing as well. There are some common themes in both of those topics that we will address and look at today. We're going to look at some recent case law. There has been some quite big decisions come through the courts within the past few weeks, and we'll run you through some of those. And then our last section will be looking at blended working and looking at and discussing what the workplace might look like for those of you who maybe have had staff, whether it's been all of your staff or some of your staff at home the past 12 months, and looking at how you might start to plan to get people back into work, and indeed what that might look like moving forward. And then there will be one last section, which I've realised I haven't put on the slides, which will look at things for you to keep a watch out for over the next few months and what might be coming in terms of employment law. This is a little bit of a whistle-stop tour. Sometimes these sessions we normally deliver can last 2 to 3 hours. So if you do have any questions, please do ask them today, or indeed there's lots of further notes on both the Acas website, the government website, and I will signpost you to other sources of information as we go through today's session. So let's look at our first discussion point, the no jab, no job. With the vaccination programme continuing at pace, employers may certainly be faced with many questions and queries about the vaccine. Employers may feel that staff getting vaccinated is possibly the quickest and the safest way to reopening and the best way to ensure health and safety of their staff, clients and customers. Employers have got to try and balance the duty of care that they have towards their employees and their customers versus respecting the liberties and the individual choice of the individuals within the workplace. One of the key questions is, can an employer insist on vaccination? And this question has certainly raised some interesting legal questions and discussions of recent. One first thing to remember is that the government policy on vaccination is that vaccination is voluntary. They have strongly advised, promoted and encouraged all of us to take part in the vaccination programme, but they haven't insisted that we have to do it. They have put together many PR campaigns. They've planned a vaccination programme that is easily reachable for all of us and easy to access, but again, not insisted that we have to do it. So how might an employer then consider if they do need to make it compulsory within their workplace? There may be certain job roles where it may be necessary, such as working with vulnerable people, if you work within the care sector, airlines, and possibly if travel is essential for the role that people have to carry out, if they've got to carry a vaccination passport. In many circumstances, it will be looking about the key facts of the situation that you find yourself in, related to your sector, your business, and the job role of the person. In many sectors, there have now been measures in place for 12 months to mitigate the health and safety risk of COVID within the workplace. And certainly those are things that should continue to help mitigate those risks while the vaccination programme continues. Let's look at some further discussions about the no jab, no job. You may have read in the media recent reports about some contractual clauses being put into contracts for new employees. As I've said, it may well be necessary for certain job roles, and it's certainly something that employers may need to consider. There are some legal discussions to consider also, for example, around age discrimination. The younger people at the moment are having to wait longer for their vaccination, and some may be, it could well be the summer or the autumn before some younger people will have their jab. So potentially will they miss out on a job offer if they haven't had their vaccination. Insisting on existing employees having a vaccination may well lead to a change in their terms and conditions of their contract. If this is something that you do wish to consider, it may be that you have got trade unions that you work alongside with, or you have got employee reps that you can communicate with. And if you think back to my previous comments about the government approach to the vaccination programme, about the encouraging, educating, signposting for help and making things accessible, those are all strategies that as employers can be useful to help you in managing the situation if you do find that you may have to alter terms and conditions. With regard to some other legal discussions around the no jab and no job, it's also been reported that there are some people who do not wish to have the vaccine, and that can be for a variety of reasons. Some of it is for religious or belief reasons. Some of it may be to do, or some reasons may be to do with existing health conditions. Pregnant ladies can't have the vaccination, so again there are some potential risks around discrimination and insisting that that your staff would have the vaccination. It also brings the question about the human rights, and does imposing or insisting the vaccination, does that breach people's human rights and the right to a personal life? So certainly some really, really interesting discussions for employers if this is something that you do need to consider, and discussions to have with your employees, your reps, and those people who are going to be impacted by these decisions. The last few things to consider is if you are holding health records about your employees with regards to their vaccination status, again, you may need to refer to the Information Commissioner's Office for further guidance. The health records and the vaccination records will be personal information, and employees may well be concerned about how that information will be stored, processed, what information you may need, and how that would be stored in line with GDPR regulations. So the last talking point on the no jab, no job discussion is to consider, what if your employees don't want to get it or don't have the vaccine? How will they be treated within the workplace? How will that information be respected? How will that situation be managed by line managers and indeed the employee themselves? Certainly things to consider with regards going forward. That the impact some of those conversations may have also on employee relations, and ensuring that there can still be room for people to come to line managers to have discussions about quite personal situations if they're choosing not to have the vaccination. So the key message for this is that asking somebody to agree is very different from telling them that they must have the vaccination. So lots of sources of help to help educate the staff, and having conversations to help them understand the reasons why you may be asking for them to have the vaccination, addressing any concerns that they may have, using clarity and transparency of information, and indeed signposting them to NHS and GP, etc., where they can get further medical guidance and help if necessary. Okay, so our next point for discussion is workplace testing. And like the vaccination, testing is also voluntary. The most recent figure that I've found for the number of workplaces who have taken up the opportunity to provide workplace tests was 48,000 workplaces who have signed up to start workplace testing. That was last week's figure, so I appreciate that may be more by now, and I believe workplaces have until the end of March to sign up if they do wish to provide this. With regards testing, if this is something that you are interested in, there is lots of help and support from the government website as well as local councils in how to set up this workplace system. The key things are, again, considering the information that you're providing for your staff. There may well be concerns about why they or why you may want to test them. Also things like how you're going to test them, when that will take place, where it will take place, who will be testing them, and also considering that some people may be reluctant for testing. They may be concerned about what happens if and when they would get a positive test, or if indeed if they've been asked to isolate if there is a positive test that comes back. So one of the employers we've been working with recently has told us that they have designed a full COVID policy, and they're just in the middle of finalising it. And in that COVID policy, they have given very clear information about what happens if somebody gets a positive test, the support that is available, so the financial support, so explaining to your employees if they are having to isolate, can they work from home? Is there alternative job roles that they can do from home? What will the impact be on their finances? Can they access sick pay, or will it be full pay? And the clearer information that you can provide for your employees can help them, obviously, to buy into workplace testing, if indeed this is something that you are going to go down the road for. Also thinking about the support that's available for you as employers, and there's help and support for small and medium-sized enterprises for claiming back some isolation pay, or some sick pay, for employees who are having to isolate. So it's always worth double checking what guidance and what support there is available for you. I've talked there also about the facilities, or sorry, I've mentioned there about the facilities. What facilities have you on site for testing, and how will the testing be completed will also be a concern for some staff, and it's something worth mentioning in advance of implementing testing to help your employees again buy in to the potential system that you're going to put in place. Okay. As I've mentioned at the start, there have been some long-awaited cases, case rulings that have also been in the media, so you may have read of some of these already, but I'll talk through some of the most notable cases that have that we've found rulings on. So the big one is Uber. This has been going through the court system now since 2016, I believe it started. It's been a long-awaited ruling, and it's all about employment status as to whether the Uber drivers were classed as workers or self-employed. Okay, and the ruling was that they are classed as workers. That brings with it some employment rights, such as your national minimum wage and your holidays. The statutory protections are in place to protect the people who have no power, no negotiation, and who may well be vulnerable within the workplace relationships. And the judges in this case explained that it's important to look at the relationship that exists between employer and the workers, and that it's the relationship that's key to identifying whether these are people who the statutory provisions were designed to help. And the 4 key factors that were looked at are things such as the subordination, the dependency that the person has on the employer, the control that the employer has in that relationship, and also the hierarchical relationship. And those are the key things in looking at the situation to decide if people are workers. Another key case that was ruled on just last week was Mencap, and that was looking at sleep-ins, usually in the care sector, that if a member of staff is asleep and has sleeping facilities but may be woken during the night to complete some work, then the hours that they are awake and working would be classed as working time, but the hours that they are asleep wouldn't be classed as working time. Some staff may have to work during the night or indeed during the day. There may be quiet periods where they may be allowed to take a nap, but they may not have sufficient sleeping facilities. And in those situations, then possibly it would be that the whole shift would be working time rather than the time that they're awake. So every situation is very case specific. Okay. Another case that's been quite notable of recent is the Taylor versus Jaguar Land Rover. And in this case, those who identify as gender fluid or non-binary fall under the protection of the equality law. The claimant was employed as an engineer for Jaguar Land Rover, and for the first 20 years of employment had presented as male. In 2017, the claimant started to identify as gender fluid and started to dress in women's clothing. From then, the claimant was subjected to abusive jokes and had difficulties using the toilet facilities, had lack of support from managers, and successfully brought a claim for direct discrimination, harassment and victimisation on the grounds of gender reassignment. The judges gave some quite strong wording in the ruling, and they have said that the claimant was not supported. The claimant received no protection from exposure to serious harassment. There was no training or no enforcement of equality and diversity policies. And these are words taken straight from the ruling, that there was systemic failure. The culture was not aligned with policies, that the failings were not that of an individual manager, but that the respondent did not give them the tools to support or deal with such a situation. Overall, there was £180,000 of aggravated damages awarded to the claimant in this case, and the aggravated damages were due to the serious harassment she was subjected to, and also to the insensitive way that the respondent had defended the case. Some of the questioning was deemed to be insensitive. So the key points from that case were that the clarity around gender fluid and non-binary falling under the protection of the equality law, but also that equality and diversity training and policies are part, or should be part of the culture within an organisation, but also managed. So not just having them in place, but using them and updating them. And indeed, there was a case at Employment Appeal Tribunal where it was a much smaller employer, but the judge also noted in that case that they did have equality and diversity training in place, but that it hadn't been reviewed in 2 years, and the judge noted that that was a failure on behalf of the employer, and that the training then should have been updated regularly. So the final case that I'm going to talk about is Cubulis versus Kent Food, and this is one of the first that we started to see coming through the tribunals, which are linked to COVID. In this case, the claimant brought a claim of an unfair dismissal, but the tribunal ruled that the claimant was dismissed fairly for refusing to wear a face mask. The situation arose at a sugar factory where the claimant was delivering goods to the site, and when the claimant arrived on site, the claimant was asked to wear a face mask and refused. And the respondent followed an investigation. The respondent had policies regarding how drivers should act and behave on customer sites. They had health and safety policies, and in all cases the claimant was found during the investigation to be in breach of these policies. And the respondent also noted that they didn't feel the claimant would change their mind, would change his behaviour in future. And the reason I felt that was from the responses that he'd given during the disciplinary process. So in that case, the claimant had been dismissed fairly. Okay. Our last section is going to look at blended working. And as some of you may well have been back in the workplace for a few months, some of you may never have left the workplace, and some of you may just be starting to plan to go back. In planning how the workplace is going to look in future, or thinking about how employees may work in future, for employers it's about looking at how you can balance the employee desire or the employee need for flexible working, but still embracing that creativity and innovation, which some feel and some will argue that is more likely in face-to-face interactions. However, I also feel that many businesses will say this year that the workforce has possibly been even more creative and innovative in the way that they've responded to the pandemic, and many working from home, where many businesses have had to dramatically change ways of working and operating in different services. So there's certainly interesting discussions on both sides. The role of the line manager in these discussions and in this process is central, but also multifaceted. Right from the initial conversations with their staff, assessing how staff are feeling about getting back to work, getting back into the workplace, having discussions about how people have been impacted by the pandemic in many different ways. The line manager is also key to having conversations with the team and indeed with other managers to assess the need or frequency of those employees who have been working from home. What frequency is there now for them to attend the office? Is it that there may be a frequency for team meetings, or what is the demand for people to be there for face-to-face conversations? That will be driven very much by the job role and the purpose and the objectives of the individuals. The line manager will be central to gathering that information. Also considering the role of the line manager in supporting those people coming back to work, identifying the concerns and helping people understand why the business is taking decisions, and also gathering their input into how the back to work and the return to work can be completed. Line managers will also be in the unique position that they're able to spot and deal with conflict early. And it's part of their role also then thinking about how they can bring teams back together and rebuild. You may have teams that have had some people on furlough and others remaining at home. And some working from home, some on furlough and some in the workplace. So it's looking at how they can now start to rebuild those teams if everybody's going to be back. Also considering how managers can performance manage and build trust if the workplace or if the employees are maybe going to be working from home more often. So certainly interesting times for line managers moving forward as the new workplace emerges. Whatever route the employers may take, the most important will also be getting the buy-in from the employees in deciding who does get to work from home or who doesn't get to work from home, when people come in the office or when they don't come in the office. The conversations will be key to help people understand the decisions that have been made. Also considering how offices will look and feel different moving forward, and possibly looking at offices being more of meeting spaces for collaborative work rather than individual workspaces that we may well have been used to. By adopting the flexible working, that can help employers attract a much wider talent pool. There are some larger organisations who have expressed that they don't ever see their work return to 5 days a week ever in the office. So Unilever is one of them, and they've said that it's an old-fashioned way of working in their view. And Spotify is another organisation. So if you're looking for further information, it's worth reading their stories. With regards to contracts, if people are going to be working from home, it's worth considering whether they're going to be classed as home workers and any contractual considerations with regards when they travel into the office, what expenses, etc. That brings an end to the blended working discussion. So a last few things from me before I hand over is looking at what's coming up with regards to employment law. Every April there are statutory changes to rates of pay, statutory maternity pay, redundancy rates, compensation rates, etc. So look out for those changes which come into force from the 1st of April, but also the age bracket for the national living wage is changing. So it used to be 25 and over, it's now 23 and over. From the 1st of April, shielding advice will be withdrawn. And so if you do have employees who are shielding, it may be time to start having conversations with them if there is return to works, in the imminent period. Something that has come in is also the 52-week period for calculating holiday pay. So it used to be a 12-week average for those who had variable working hours, and it's now 52 weeks average. Further information of this can be found on Acas websites. Okay. With regards to furlough, from the 1st of July, employers will have to make contributions to the furlough payments. There is a report coming out soon. I couldn't find the date for it, from the Centre for Social Justice Disability Commission, which is aimed at tackling barriers to employment for those with a disability. The ONS statistics show that 52% of disabled people are employment, compared with 81% of non-disabled. So the world of work is missing a massive wealth of knowledge, talent and skills. And the report's going to be making 5 recommendations to try and reduce that gap. So some useful and interesting reading coming up, I feel, in that report. And finally, one big case law that's coming up is the equal pay claims from ASDA. There is a case, it's being tomorrow, I think it comes out. Decision to due tomorrow. 38,000 shop floor workers, which are mostly women, claiming that they should be paid the same as distribution centre staff. So many retail businesses eagerly awaiting that case law outcome tomorrow. So that's everything from me.
Karen, that's
Thank
amazing.
you for listening, and I will pass over.
Karen, that's amazing. You've covered so much in such a short time, and I'm sure we've got a couple of questions that I might just put to you now, just so that we can deal with these. But the resources that Karen's put up on the slide will be available afterwards on our website, so you'll be able to go and visit those. But it just shows the depth of knowledge that you and an amazing partner in Acas, Karen, and I know others maybe are on the call from Acas, and it's a big shout out and a big thank you to all of you who support the Good Employment Charter in the work that we do. A couple of questions before we move on to Lee, if I can. One's from Jenny Williams, and it's about can occupational health providers access supplies of the vaccine and carry them out as part of pre-employment health checks like they do with Hep B? I think I probably know the answer to that, and probably is no at the moment. But and the second one's about it's an old chestnut.
Yeah, the vaccine's only available on the NHS, so there's no kind of private supplies of vaccinations.
That may change down the line, I guess. But,
possibly.
Yeah,
possibly.
It may, but not at the moment. The second one's the old chestnut about who pays and who's responsible for your desk, your chair, your monitor, your display screen equipment compliance when you're working from home.
Okay. Interesting question. I suppose the answer will be a lot of what's in your own policies, and I suppose also what's financially suitable for you as a business. Also possibly thinking about some of it may well fall under reasonable adjustments for disability if people are requesting certain equipment for that. So there may well be legal considerations that you might need to take into consideration when making those decisions.
Thanks, Karen. I mean, we all saw pictures earlier in the year, well, last year, of people balancing laptops on the knees on the edge of beds or using an ironing board as a desk, clearly unacceptable. And I think that's a question that if we move forward with this blended working, that will come to the fore even more. We are planning, not next month, but the month after, to run a session specifically on blended working and the return to the workplace. So if members want to sign up for that, that will be not next month, but probably in May, we'll be running that session. So look, without further ado, thanks again, Karen. There would normally be a huge round of applause right now, but hey, we can't do that right now. So we'll just pass straight on to Lee, who's, here we go, who's going to cover some other aspects for us. Thanks, Lee.
That's great. Thank you so much. Thank you so much. Hopefully you can all hear me okay. And I'm just going to try and move the slides onto my session. So it's nice to be here this afternoon. And what I've done is I've picked out 3 areas of employment law where there are going to be some key changes, really just literally around the corner, and which all businesses need to be aware of. So that's my kind of starting point. And they're all kind of different. They're all different to what Karen's spoken about. So here they are. So first, the first one is IR35. Now, it's a very strange sounding thing, and I'm sure quite a few of you will have heard of this already, and some of you may be quite involved in it already. But basically, there are going to be some key changes to how HMRC, the tax authorities, are going to be looking at businesses who engage contractors. Okay, so just to explain a little bit about the background to this. So IR35 was a tax charging regime which was introduced as long ago as the year 2000. So if you're a business, usually you'd have employees, and of course with your employees you run their pay through PAYE, and the taxman takes a decent take in terms of income tax and national insurance, and everyone's happy, or as happy as they can be. If, however, as a business you choose to engage a self-employed person to do the work, then that person usually will submit an invoice to you at the end of the month, and you'll pay the invoice. There won't be any tax and national insurance deducted, and the HMRC for some time have been concerned about that situation, and particularly where a lot of these contractors are basically contracting through what's called an intermediary, so basically their own limited company, and hence why IR35 was introduced in the year 2000 to try to stop what the HMRC perceived as tax avoidance. So what IR35 says is that if actually, although the person is contracting to you and providing services through their limited company and being treated as being self-employed, if actually the relationship is one of employment, then the service company that they're using to deliver their services has to operate PAYE on the payments to them. Okay, so it has until now it's been no concern of the organization engaging their labor. You can still carry on paying their invoices, and that's fine. And it's their service company that has to account for tax and national insurance on the payments. And this is the big change that I'm going to flag up very, very soon. So I mentioned, if the relationship is one of employment, or deemed employment as it's called, well, what is a bit of a strange thing, isn't it? If you're deciding to be self-employed and provide your services through, as a self-employed person, how come somebody can turn around and say, well, it's actually employment? It's a very strange situation, but that is exactly the situation. So what HMRC can do on a payroll audit, an inspection, they can come into your business and they can look through the people you're engaging, and they can say, well, actually, we think they're employees. We don't think they're self-employed, really, when you look at the relationship and how it's working, and therefore we're going to assess you for all the back income tax and national insurance that should have been accounted for. Okay, and that's the risk, that the person actually, although you're choosing to call them self-employed and you're happy to engage them as self-employed, the risk really is that it could be an employment relationship in disguise. How do you know whether it's an employment relationship in disguise? Well, there's a whole piece around employment status, which I'm not going to take you through this afternoon. Some of you may have seen the online CEST tool, CEST, which is on the HMRC website. But basically, you have to look at how the relationship's working. So some of the key points. If actually the person hasn't got their own business, they're just working for you. If they're working, fixed hours, if they are working on in your premises and not supplying their own tools and equipment, if they haven't got any other customers or clients, if they're integrated into your business, then it's very likely, isn't it, that HMRC would see them as employees. So the label that you choose to attach and the way the parties want to deal with each other is irrelevant to the true nature of the relationship. Okay, so What are these changes then? Well, it's a massive shift. So all the risk of this arrangement, which used to sit with the person supplying the services and used to sit with their intermediary, now transfers onto the company who's engaging their services from the 6th of April this year. Okay, so this is being called off payroll working. It's a change to the IR35 regime, where HMRC, they don't now have to go after lots of small intermediaries. They can just look at a business, you know, particularly large businesses, and they can say, we're going to inspect all of your contractors and, you know, ultimately determine whether they are within or outside of IR35. So that's the big change. Slight sigh of relief, because these changes coming into the private sector, they only affect clients who are engaging contractors where the client is medium size or large. Okay, so there's a definition in the Companies Act of what a medium or large employer is, and if you are a medium or large employer, then you're affected by these changes. If you're a small employer, so basically your annual turnover is less than 10.2 million, your balance sheet is not more than 5.1 million, and you've not got more than 50 employees. So if 2 or more of those factors are present, then you are a small employer, and at least for the moment, you're not caught by these changes. Okay, so it's really the larger employers out there, and it's designed to try and increase the tax take and to make it easier for HMRC to enforce. Okay, so what do you need to do if you're a medium or large employer? I've just put a note there, sorry, on the slides about the 1.2 billion that's estimated as not being collected in taxes due to people engaging contractors and, you know, not dealing with them really as employees. And what do you need to do? Sorry, I've gone the wrong slide. Let me get to the right slide. 1 second. Here we go. What will you need to do if you're a medium or larger employer? Well, what you've got to do is obviously look at the status of who you're engaging with. You've got to conduct a status determination, which has got to be done in writing and provided to the person, the contractor. There's got to be a dispute mechanism where if they think actually they should be outside of IR35, you've got to then look at it again. And ultimately, you've got to operate PAYE on the payment. So this is going to lead to a large change, isn't it? We've already seen a lot of changes in the economy. This is another one of them. So some of the large banks have announced that they're just not having IT contractors in place any longer because it's too much hassle and or too risky. So we've seen a big move already away from this type of contracting. But certainly there's still a role for it. If people are genuinely self-employed, then there's no reason at all why that shouldn't continue, and that the client would ultimately, the person requiring the services, the client, would issue a status determination saying they've considered it and they do genuinely believe that it's self-employment and they can carry on paying the invoices on a gross basis. So hopefully that kind of flags up the upcoming IR35 change. Employment status is the difficult issue there, isn't it, really? And that's where we're really helping clients at the moment, doing status assessments, looking into arrangements and giving them a view on whether we think it ultimately might be within or outside of IR35. Okay, moving on, totally different subject, but one of which is, again, should be on the minds of businesses, particularly good employers, of course, gender pay gap reporting. And in terms of the background to this, it remains a fact that within the UK, and I think most economies, men are paid more than women. And that's something that should be tackled and is being tackled by lots of businesses. And this is the government's way of giving you a incentive, if you like, to do so, because employers for a couple of years now have been required to report and publish their gender pay gap. So cast our mind back to 2015, we had David Cameron. Everyone remember David Cameron? Seems like a long time ago since he was the Prime Minister. David Cameron announced that he would end the gender pay gap in a generation. Okay, a bold statement. Back in 1997, when the Office for National Statistics started reporting on average pay for men and women in the UK, there was a pay gap of 27.5%. A huge number, isn't it? Very, very, very unfair. Now, fast forward to 2016, just before the gender pay gap regulations were introduced, and the pay gap between female pay and male pay across full-time employees was 9.4%. Okay, in the UK, still a big percentage. If you look across all workers, if you include part-time workers as well, so across all workers, that pay gap rises to 18.1%. There are disproportionately more female part-time workers, and part-time work is not as well paid as full-time work. So the gender pay gap was still very much with us in 2016. So we had the regulations that came in, and what the regulations require larger employers to do is to take a pay snapshot in or around April of each year and crunch the numbers and come up with an average hourly rate that you pay your male workers compared to your female workers, and also to put the pay into 4 quartiles. So basically ranking people across your business and looking at how many females and males are in the top quarter, and then the middle and the quarters and the bottom quarter, and also to report on your gender bonus gap as well. So if you're paying a bonus, that's brought into the equation. So quite a stringent set of requirements. These requirements apply, by the way, to employers who employ more 250 or more employees. Okay, so again, you might think, oh, that's okay, my organization's not affected, but I think the general consensus is that gender pay gap should be everyone's business, and people will ask questions about your business, and ultimately the government might decide to lower the threshold in due course and require smaller businesses to start looking at this as well. So it's obviously a thing which is important to consider. Now, the gender pay reports that came trickling in and then came in as a flood in April of 2018. I think I'm right in saying. April of 2018 was the first reporting period, and that showed that in the finance sector, so banks, building societies, City of London, financial institutions, the pay gap was 35.1% on average, whereas in the hotel and food and catering sector, the pay gap was 1%. So we can see a massive disparity across different sectors. Some sectors, everyone gets paid a standard rate pretty much, minimum wage or just above, and there's no pay gap or virtually none. Whereas the larger organisations, well, financial organisations have got a long way to go. And the critical thing here is that the gender pay gap regulations don't require you to actually do anything other than just publish your gender pay gap information. So, a lot of people have said, well, it's a good start, but actually, should there not be an obligation somewhere to actually do something about this? So that's an interesting point. What could you do as a business? So what might your action plans be? Well, these are some things that have been tried by other businesses and some of our clients. We've been advising on some of these things, but can you have, or should you have, should you try and have a minimum number of females on interview shortlists for jobs? There's a lot of talk about quotas. Some people think they're a good idea. They're a necessary thing to do. Some people don't think it's tokenism and they shouldn't be around. Look at your interview process. Who are you promoting, and on what basis? Are you doing it on a kind of a really rambling interview? They seem like the right person. We're going to appoint them, or is it more structured? It is apparently a fact that men negotiate their salary harder than women. I don't know if that's true, but that certainly seems to be accepted as a fact. So again, that kind of partly explains the disparity. But again, could you encourage some level of published pay bands rather than particular pay, and encourage negotiation? Make things more transparent. But I think the key thing really is what's preventing your female employees progressing into the top jobs, the jobs that are paid more. And I think we can see the barriers there. Women disproportionately have to have childcare commitments still, despite the the best efforts to try and equalise that in terms of shared parental pay, and sharing the burden, looking after elderly relatives. That's going to become more and more difficult. But again, statistically, females tend to do that as well. So they take time off, and when they come back, the job isn't the same job as they came back to, and generally speaking, it interrupts their career progression, it seems. So what are we going to do to try to address that? It's really interesting debate. One thing I would mention as well is obviously how far can you go? Because if you actually appoint a woman who's as equally qualified as a man to do a job, you're going to get into hot water, aren't you, with sex discrimination potentially, and the claim from the disappointed male job applicant. So you still can't discriminate against people on the grounds of sex. Of course you can't, but the Equality Act does allow a certain amount of what's called positive action. So you could try to encourage female job applicants without falling foul of sex discrimination. In a very small number of cases, you could actually ring fence a job for a female applicant, but that's problematic. You have to be able to genuinely show that that's an occupational qualification to do that job, which is difficult. So interesting times. The other thing just to mention is everything's due to COVID, isn't it, at the moment? But due to the effects of COVID, the reporting for this year has been extended by another 6 months. So the reports would have been due in round about April, and that reporting period has been extended to October because obviously businesses are struggling at the moment, but it's certainly not going to go away. Okay, final quick mention. Employment lawyers like myself are slightly obsessed about non-compete clauses because often it leads to disputes. People will have a clause in their contract that says if they leave employment, they won't set up a competing business, they won't take away your customers or your employees, and are those clauses enforceable? And the answer is the answer is it depends, but you've got to show that you had a legitimate business interest to protect and that the clause doesn't go any further than is reasonable. So the law already caters for this, but just to flag up there that the government have just concluded a consultation on whether to ban these clauses. So it could be quite a big issue for a lot of businesses. Do these clauses hamper innovation and entrepreneurship, particularly as we're needing to restart the economy? Should they be abolished? Should alternatively, and I think many commentators, including myself, think this is likely, should you have to pay for a non-compete clause? So you can have it, but ultimately you have to pay a percentage of what would have been their salary during the non-compete period. So interesting. If anybody does want to discuss these things further, by the way, or want to get in touch, you're welcome to do so through email or just through LinkedIn or whatever else. I think we're just about reached time, and there may be some questions, Ian.
Lee, thank you very much indeed. I haven't seen any questions come through, so if anybody has got questions, can they please pop them in the questions tab? I don't know if Karen's still there. She's going to rejoin us. I think she just dropped off the stage. But Lee, thank you again. Comprehensive in quite a short time. And I think your next slide has some resources as well. And again, we will put that up on our website, and people can revisit the webinar to re-listen to the information you've been given, but also to track down Karen and Lee and probe them further on the information that they've given today, which has been superb and comprehensive. One of the things that we talked about last year, Karen, and when you think about and when you think about it, it's almost unbelievable that we still, we haven't mentioned it at all this year, is Brexit and the implications around particularly recruiting foreign nationals. Now, you got anything that you'd want to just share quickly on that?
I know we'd spent so long talking about it, hadn't we, COVID, and then, as you said, it's gone off the agenda a little bit. With regards employing employing any kind of EU nationals working for you before the 31st of December, that will still remain the same until June 2021. So i.e. they can apply for settled or pre-settled status depending on the length of time that they've been living in the UK. If you're recruiting from January 2021, there is the new points system, and you may also need to apply to be a sponsor. Lots and lots of information on the government website on the point system and how it works. I think they need 70 points and you can trade some for different criteria. So yeah, lots and lots of information. The government website's really useful for that. Thanks,
Karen. Yeah, how times have changed. Again, look, thank you very much, Karen and Lee, for your support today, but throughout the course of the Charter. You've been there for us to help and guide us. It's been fantastic to work with you. I think exactly, nice to see everyone. Lee, thanks for your comments. It was a gallop through, but it's comprehensive, and it's definitely something that we really enjoy doing every year, is this session. I think many of the issues that you've both raised have been picked up and are included in our content moving forward, particularly the gender issues, the LGBTQ plus issues, issues that we will be addressing either through webinars, blogs, some roundtables, and also one of our latest innovations is we've now got a podcast. For those of you out there who haven't already subscribed, go to wherever you get your podcasts, whether it be iTunes, Spotify, whatever, and we've called it Good Employment Chatter. You're all supposed to laugh at that. It will catch. I'm sure it'll catch on. At the moment, we've got a series of interviews with people. The current episode is out with a discussion with the mayor, but we've got a number of personalities across GM that we're chatting to, including, here we go, Sacha Lord, Sakari Cooper, Diane Modal, etc. So please subscribe and download. It's only half an hour's listen, and you can, whatever you're doing, you can just have that on in the background. Thanks again, Karen and Lee. Look forward to seeing everyone next month at the webinar, and hopefully in the not too distant future we might be able to do one of these face to face again. Thanks everyone, and have a good afternoon.
Thank you.
Thank you.